Can you hear me?
Yes, I can hear you. Are we good?
Yeah, we could not. Thank you so much, everyone, for joining us today. And now, Nos, can you start with your introduction?
Okay, all right, perfect. As long as we know that everyone is on board and everyone who has their mic on has to have their mic on. Greetings to everyone. Otherwise known as Nos Royale. As I'll be controlling the meeting from this side, I'll just put certain people on mute if they're not talking at that very point in time. So welcome to the lockdown chat with Nos and Mbuyi. We've had a whole season of multiple episodes, but this week we wanted to close off looking at the law and how South Africa has implicated during this pandemic. So I'd like to start off by reading a short introduction before we start with our. It is said that the law is but the tool, not the driving force of the great society, that it must remain ever servant, never master. Beyond the health and economic repercussions that have been presented by the COVID-19 global pandemic, furthermore, it has also brought about major disruptions in our daily lives, as we are witnessing retrenchments of many employees, the rise of gender-based violence statistics, many people resorting to initiating divorce proceedings, and some claiming against the state of infringement of their rights during this period. As the state, through its law enforcement agencies, have had to enforce many strategies which somehow infringe upon many fundamental rights of the people, including the right of movement and human dignity. So everyone, I welcome you, Umenzi Akane and Mbuso Tuenza, who have joined us today to answer some of these riveting questions. Welcome to the Lockdown Chat with Nos and Mbuyi. Thank you.
Thank you. Thank you for.
You're welcome. As a disclaimer, moving forward, our network bandwidth is really, really bad. We do find a lot of strain. Sometimes if I do get kicked out of the meeting, Mbuyiselo will continue, but do bear with us with technology and network.
Okay.
So starting with Mbuso, maybe we'll take turns with Mbuso and Umenzi. If you can quickly introduce yourselves, your positions as practitioners, and what do you do and what do you most Mbuso, we can.
Okay. All right. I am from KZN. That's where I was born. It's the Kawini. I am 24 years old, and I'm a practicing attorney with LNP attorneys. I am in associate in their construction and engineering department, but I also have a number of dispute resolution matters that I'm working with. So that is my brief introduction professionally. Yeah, but personally, yeah, what you see is what you get.
Okay. Menzi, can we please hear from you, your position and what you do currently?
Okay, thank you, Nos. I'm Menzi Sikakane, an admitted attorney of the High Court of South Africa. I served my of clerkship with I'm the legal practitioner or professional assistant at University of Zululand Law Clinic. I'm mostly specializing in criminal law.
And to start off, how have you been affected by the COVID-19 pandemic and the lockdown?
Starting with me, Ombuso.
We're with you, Menz. We'll continue with you.
Yeah.
Okay. Okay. You know, as a legal practitioners, ever since these regulations were put in place, we couldn't go as we please because you cannot go to court as you like or as you wish. You only need a permit, which is to be issued by the legal professional council, which is in Pietermaritzburg. So what I can say, the advantage or disadvantages which were brought by the lockdown to us as legal practitioners is that we couldn't perform our work as we like. We couldn't move as we like because we did not, it was not easy to get these permits which were allowing us to attend to court. We ended up utilizing the technology, postponing matters or over the phone. You phone the prosecutor and you arrange a next future date. But we were not allowed to go to court because of this lockdown and regulations of the Disaster Management Act, which were placed into operation by the minister.
Are there currently any forms of technology that have been put in place to assist and mitigate these problems, the restrictions that you currently have physically? Are there any other technological solutions?
Okay, no, currently I can say there are none. There are none. We only resort in using telephone calls. There are no Zoom. There are no platforms like this one, because we cannot conduct a trial over a Zoom call. You only have to be there physically. So we only utilize the cell phone call. We phone them. We postpone the matters over the cell phones. That's what we've been doing. But hopefully, as we move to level 3, maybe some restrictions are lifted, then we will be able to perform our work freely.
Mbuso, can I throw questions to you now? How you directly have been affected by the pandemic and the restrictions of lockdown?
Okay, thank you so much. With us this side, I can say it's slightly different than KZN. Obviously, I'm in construction and dispute resolution. So most of my matters, it is negotiating contracts, I am reviewing contracts, I am holding Skype meetings and Zoom meetings, mainly to discuss the contracts with the client, etc. So from our side, I can say we've been able to do our work. We're working from home, obviously. Things have been hectic in the sense that you're receiving more tasks and less assistance than you would be at the office. But work has been moving, and I can say that the results have been more or less the same, because if all I need to do is have my laptop and have my network and have my content to get the work done, that more or less does not necessarily need me to be at the office, if we are going to be honest. But with regards to dispute resolution matters, for matters that are at arbitration stage, it has obviously been very hard to actually get them sitting down, because you can't in a way have a matter run over Zoom or Skype. But for some matters with regards to civil procedure and with the courts have been quite very open to the idea of having the matter sit over Skype and sit over Zoom. I mean, we've seen people getting admitted as attorneys over Skype and over Zoom, and we've seen some applications moving over Skype and Zoom. So I can say that this side, there has been a bit of a progression with regards to the use of technology and the use of the computer and the network we have in front of us. So I can say that the matters have been quite flowing from the side.
Do you see that as the new normal, which will continue that way?
Fortunately enough, there's an article that we wrote at the office which answers to this last year, where we were addressing the issue of whether, can witnesses testify over Skype and Zoom? And the answer is yes. I mean, at that time, it was just theoretical. But now we're moving into a world where obviously there is a use of technology, and we need to try and make sure that the technology is used, because if we are going to have to go to court for appearances, especially if there isn't going to be an interrogation of witnesses. Yes, we do need that to happen, but it doesn't mean that we can't use technology for matters where we do not need witnesses. So I do believe that is the new norm, and it might be actually quite appreciated if that is the new norm, because we are moving at a time where the use of technology has to come also in handy, and we need to ensure that we tweak the rules and tweak the acts to allow for people to have matters heard over Skype and Zoom. So I do think it is going to be a new norm, not completely, because our law still expects, for example, in a criminal trial, we still expect the accused to confront the witnesses, and there would be no confrontation over Skype or Zoom. And there are also certain elements of the credibility of the evidence that is being given. So the court might need to consider that when it allows people to testify over Zoom. But for matters where we do not need the other side, or there would not necessarily be any confrontation of the witnesses or the reading of evidence per se, I think it's going to be the new norm, to save time and space in the courtroom and just make sure that we are going there for something that we know is legit legal fighting and not just procedural matters.
Thank you so much, Mbuso. To Umenzi, we know that you are working at a law clinic and you give, or rather render, services to the indigent members of the community, which are people who most disadvantaged people. Now, how are you guys at the law clinic trying to mitigate the challenge right now, since you cannot have face-to-face consultations? How are you keeping communication with your clients at this point in time?
Okay, at the law clinic, to try to mitigate every loss that may happen, we have came up with a plan now of conducting these Zooms conference or Zoom calls, whereby we identify a topic that may be of necessary need to our clients or potential clients even. Then we address that topic over Zoom. We record that Zoom conference. Then it is posted on a podcast where everyone can have access on it. That's how we have tried to mitigate this situation which we are currently facing as the nation.
Yeah, and I'm glad, Menzi, that you're speaking about accessibility, because I was wondering that if you guys are having meetings on Zoom, how can the people who cannot even afford legal fees then be able to afford to log on Zoom? Because we all know that it charges a lot of data. So, but now that you've clarified that it's available through podcast, I really now understand. Back to Mbuso. Mbuso, you spoke about dispute resolution. Right now, if you would watch the news and listen on your radio, most people are speaking about retrenchment now. Companies are implementing retrenchments. Can you tell us, and to those who does not even know anything about retrenchment or even law, what is retrenchment, and probably what is a proper and fair procedure for conducting retrenchments on the firms by companies?
Okay, so the employment relationship primarily exists because there is an employment contract and there are certain employment conditions that employees need to abide by. Now, there comes a time where a person commits an offense in the workplace and then they get dismissed for misconduct. Then there comes a time where there are certain interests that changes on the employer side. There we are speaking technology, there we are speaking resources, we are speaking profits. And we are also speaking this pandemic that is currently happening at this point. Now, the law has allowed employers to be in a position of dismissing employees based on these operational requirements. So it's called operational requirements because the employer cannot reach its targets and cannot administer their functions if they do not dismiss some of the employees. Now, the process of the procedure is just, it's a simple and straightforward procedure, but because the relationship that exists between employers and employees is primarily one that does not really operate on a straight and narrow, because employers do what they want sometimes and employees do what they also want at some point. But the first thing that needs to happen in a possible eviction, possible retrenchment, sorry, is that we need to have consultations. Now, the consultations we are going to have are consultations where we determine whether are we really at a point where we can dismiss employees, or there are certain measures we can implement that can try and save jobs. Now, the consultations are said to be consultations which must be in good faith and which must try and ensure that we reach a joint consensus, because there must be an agreement in the mutual meeting of minds at that point, because you have not decided you want to dismiss people. You just want to find out whether they are amenable to the idea and how they can help you to try and ensure that they save their jobs. So unfortunately, half the time when employers recommend retrenchment, it's because they have decided that they want to retrench. So whether we can hold consultations, whatever is laid in the consultations, they don't really care because they've made up their minds. But in a good world where employers are law-abiding and they're sticking to what the law says, we need to have consultations. The consultations must be with the people that are said to be involved or that needs to be involved. Now, in the workplace, there's something called a collective agreement, or any agreement that regulates how the trade unions and the employers and the employees will resolve any disputes. Usually there are sections of this in the collective agreement. So the collective agreement would basically state who needs to be there. And in stating who needs to be there, those people need to be consulted with. And after those consultations have been held, we need to reach a point where now the employer goes back and discusses or finds out whether they can be able to meet these conditions or these circumstances. Thereafter, the employer then needs to give a notice of retrenchment to employees, because this notice then makes employees know that there is a possibility of being retrenched. Now, upon being given that notice, you then have about 30 days where you can serve your function, and after the 30 days, then your employment relationship will be terminated. So the kind of problems that we are going to have with this pandemic is that, for example, people have used up their leave days. And the question then would be, if they've used up their leave days, was that supposed to be part of what the employer decides or part of what the employee decides? And because of those kind of problems, we are going to have a lot of these issues coming in. And unfortunately, whether you're a small practice, or whether you are a big company, you're going to be touched by retrenchments, because if we are going to be honest, especially law firms, they've not been able to get in as much profit as they should. And if you're going to speak big industries, if you're going to speak big construction companies, they've not been able to do any work for a period of 2 months. And that is them operating at a loss, and probably a loss that they can never really recover. So because of those elements, we are going to get into a time where employers are definitely going to start the negotiations on dismissals, and the dismissals will be based on these operational requirements. Now, one of the steps in these in this procedure, you are allowed as an employee to request an employer to make certain disclosures of, for example, if they're saying they're dismissing you because revenue has not been coming in, you're allowed to request them to actually give you their figures and give you their revenue stats so that you can confirm that really they were in a position, or they are in a position to dismiss you. Now, because of that whole procedure, one needs to be aware that the procedure on dismissals, it is more detailed and much more than what I've mentioned. But because of the current pandemic and the time that we have, and the fact that we try not to make this a too legal conversation, that's primarily what needs to happen. And that's what the compliance needs to be on the side of the employer. But the procedure on dismissals for operational requirements, it needs an employer to have an honest discussion with the employees, and it needs employees to also be at a position where they understand where the employer is coming from, understanding that we need money, understanding that we need jobs. It's most definitely going to be hard, but it is something that we need to face reality to happen.
It's perfect. Thank you. Thank you. Throwing this question to Umenzi, I want to touch on the issues of gender-based violence. Are there any rising cases at this time? I know we had a conversation earlier about mental wellness and the psychology of the effects of people right now under confinement. And we know there's influence of alcohol and so many other issues. Any rising cases of gender-based violence that we're seeing and you could be dealing with going on after lockdown?
Thank you, Nos. Although we have not yet received any instructions relating to domestic violence matters, gender-based violence matters, but if you liaise with the prosecutors in courts, they revealed the couples are now spending most of the time together, whereas before that was not the case, because maybe you'd see that one of them or both of them, they wake up in the morning and go to work and only come back in the evening. So now they spend a lot of time together, which has made one of them or either part to develop some feelings or dislike the other part. Then as a result, they end up committing these gender-based violences against each other. So in court, the cases have been reported, but because of the lockdown, the clients could not be able to approach us because there were those restrictions of movement, you know. But as soon as these restrictions have been uplifted, we are expecting clients to approach us and give us instructions to represent them in matters of gender-based violence, because a lot of them have been reported to the police and most people have been arrested for these offenses.
You're touching on something very important, mentioning the police. What are the cases that you've seen against the policemen themselves? We know of people that have been wrongly attacked and violated by the police power. What's the law doing about it at this point?
I beg your pardon, Nos, I didn't get the question well.
The issue of police brutality against civilians. What is the law doing about that at this point?
Oh. Okay, thank you, Nos. Okay, I think it's lack of information and knowledge to our people. You know, everyone has a right in South Africa. No one has a right to assault another person. So if a police person or a police official assaults another person or commits any act of brutality to a civilian, that is a criminal offense. But due to lack of knowledge, people do not open cases against the police. But once a person has opened a case against a police official, firstly, internally, that police official gets suspended. And then a criminal case will be opened, and normally the cases opened against members of SAPS, which is South African Police Services, are investigated by the IP. So that person will open a criminal case, and he or she has a second remedy of suing now in quantum or in damages, a civil claim against the Minister of Police. But people lack that information. They do not do anything. They should be opening criminal cases against police officials and lay civil claims against those police officials who have committed an act of brutality against them.
Menzi, I've got a follow-up question from Nos's question. You in the previous question you were asked about gender-based violence, and you spoke about arrest and also detainment. I want to ask, if someone is detained at this point during while there's lockdown, if they were to apply for bail, will they be granted bail right now, or probably they'd have to wait in the cells until lockdown, maybe I don't know, maybe to another level, or once the lockdown is over? Just give us information around that.
Okay, thank you. Everyone has a right to bail. Everyone has a right to bail, and if you are arrested, it is within your rights that you are brought before a court of law within or after the expiry of 48 hours. So regardless of the crime that you had committed, you are still entitled to get bail. If you get arrested even during this lockdown, your right to apply for bail will have to be exercised. You will have to exercise that right for you to apply for bail, and you will be granted bail if the merits permit so. So you will know that there are 3 different schedules when it comes to bail. If maybe you are arrested for an offense listed under Schedule 1, okay, you will get bail on the first appearance. If it's either Schedule 5 or Schedule 5, maybe you can be granted bail after 7 days, after you have spent 7 days in custody and after the matter has been investigated properly. But to answer your question, yes, you do get a bail even if you are arrested during this lockdown period.
Okay, that is good news to the people out there. But that does not mean people must go and commit crime. Back to Umbuso. I heard you speaking about meeting of minds, but when you were speaking in the labor law context. But I want to come back to law of contract. So we all know that, okay, if there are, in a contract there are 2 or more parties, right now during the lockdown period, there's a certain party probably in a contract who cannot fulfill his obligations, maybe due to the lockdown restrictions. Maybe the person has to transport something to another province, but they can't because it's not essential. What happens? What happens in that circumstance when someone cannot fulfill their contractual duty and they are actually justified for doing so because they cannot go above the law or contravene the lockdown restrictions? So can I just then go and say that person is actually breaching their contractual duty or obligation?
All right. Whoa. So what you're talking about in construction law is referred to as compensation events. So if, for example, you can't carry out your duties as a result of a certain obstacle that is beyond you and that you could not have detected earlier, you are entitled to inform the other party that you're not going to be able to carry out your duties, and thereafter inform the other party that you've tried to exhaust all the means on your side, but you're not in a position to do so, and inform the other party that you are going to obviously run to certain cost in you not being able to have done what you were supposed to do. And it's a whole fresh dispute of whether you're entitled to those costs or not, which is another time and another subject. But there's usually something in the contract that is referred to as a force majeure. The force majeure clause, it is the one that states or sets out what one needs to do when they are in a position where they're not able to act or carry out the duties that they were supposed to carry out. So for example, if you're not able to carry out those duties, you're able to inform the other party that you won't be able to obviously carry out these duties. And it goes to the whole understanding of the contracting parties acting in good faith, because if you're acting in good faith, you will obviously understand that because of the lockdown and the regulations, the moment the truck moves to another province, it is breaking the regulations and breaking the law. And they can't suffer those consequences because of the fact that you want delivery to be done. And as a result, in good faith, you have to be in understanding of what is happening and obviously observe that. There's also something in construction called the change in law, depending on the kind of contract you use. But if there is a change in the law, you have to inform the other party that, listen, the laws have changed, regulations have been passed, we can't do deliveries, we can't do anything, and as a result, we are not in a position to do our work, and that's why we are not going to be able to fulfill those conditions. These are the kind of issues that then leads to parties fighting at a later stage, and we're going to see a whole lot of that after this lockdown business is gone. But hopefully parties are able to act in good faith, and if one needs money, give the other money, and if one needs time, give the other time, and if one can't be able to do what they're expected to do, be reasonable and act in good faith.
Okay, thank you. something that might be slightly away from necessarily construction. I'd like to know about property, residential property, and dealing with tenants, issues like that. I've seen a notification from one industry. I'm saying a building owner allowing people 4 months to not pay rent. So some landlords have allowed their tenants to not pay rent for like the next 3 to 4 months, but others are not, and others still have to pay. What are some of those issues, and what can you advise in those situations of what is actually the best step to take for people during this pandemic for them to recover?
All right, thank you. So just something straightforward. All rental matters are taken to the Rental and Housing Tribunal. So the Rental Housing Tribunal is the tribunal that deals with all matters relating to rental. Payment of rental, they're not fixing my light bulb, they're not fixing my air conditioner, they're, anything that you are complaining about, you take it to the Rental Housing Tribunal. That's the first thing. With regards to the COVID-19 and rental, in good faith and in negotiation skills, the landlords have allowed tenants to paying rent certain times where they won't be able to pay a rent. I mean, in my building, we've been allowed to make submissions. If you've not been paid, whatever the case may be, you submit, and then the body corporate looks at it and decide if you are worth their mercy. But what's important is you have to pay your rental, and your rental needs to be paid on time. Lockdown or not, the fact that you are living there and you're doing everything there, you need to pay rent. Unfortunately, some landlords are not going to hear the whole minutiae of why you're not able to pay your rental, and that's when the issues of the housing tribunal comes in. I don't know where the housing tribunals are in your provinces, but I know that in my province, it's in CBD, Marshalltown. You call them, you go there, they give you a form, you fill out that form, you submit it. They call the other party to come and sit down for a negotiation. If a negotiation is not reached, they then take you guys straight to sort of a trial situation. You lead your evidence on why you believe your landlord is being unfair. The landlord lead evidence on why they believe they're being fair. Then the tribunal passes the judgment. One thing good about that tribunal is that their judgment is enforceable. In a criminal court, you can get arrested if you are breaching it, and for civil and in civil law, you can also sue for damages. So it is a good place for people to go and a good place to start. It's accessible, it's free, but the long and the short is the rental must be in at the time it's supposed to be in, and if you can't, negotiations and discussions in good faith on why you can't do that are very much preferred and required.
Thank you for that answer.
Yes, Mbuyi, so while you were speaking, I'm just thinking that there are so many remedies that people have, and it's just that people do not know. And I always say when people are lacking knowledge, it's easy to be exploited, and you find yourself going, taking a wrong route just because you did not know that there is actually a remedy that you could actually take. Now, and Mbuyi was also serving at Wits Law Clinic, and Umenzi is also at the University Law Clinic, which I can also say we can also advise our attendees and our people who are our subscribers, that they need to use law clinics and centers that are available in various communities that are available to help the people who cannot afford legal services. One last question that I have for Umenzi. Right now, there are people who are contravening lockdown restrictions. So stay in a certain town, then this person travels, but what happens to those fines that umuntu awatolayo right now? Is it fair ukuthi ngifine during lockdown noma yabo menza ngichazela kabanzi ngalokho?
Okay, thank you, Mbuyi. If you get a written notice to appear in court in terms of Section 56 of the CPA, Criminal Procedure Act, which will have a certain portion which will require you to pay an admission of guilty fine. So normally people will like the shortcuts. They would pay an admission of guilt of AG right there on the spot. It has bad disadvantages though, because if you pay an admission of guilty fine, you will have a criminal record in the future. So if they tell you about the admission of guilty fine, they do not explain to you that by paying this money, you are admitting that you are guilty of this offense, therefore you will have a criminal record. So in the future, we'll meet people who will say, the police did not explain that to me. Now I cannot get a job with government because I have a previous conviction. So I would advise people and the subscribers not to pay the admission of guilty fine. Follow the length procedure, go to court, apply for bail, and instruct attorneys to defend you in that matter. For instance, let's say you are rushing someone in hospital and you are apprehended by the police along the road. You don't have a permit, right? But in court, you can raise a defense the defense of necessity, that it was necessary for me to rush this person to the hospital because had I not done that, this person should have lost his or her life. But the police will not understand that. That is the terminology that you can use in court. That defense can be understood by the magistrate and the prosecutor. So do not cut the stories short. Do not follow the shortcuts.